The defendant's motion to suppress wiretap interceptions. The defendant's motion to dismiss the indictment for pre-indictment delay or to exclude evidence. The motion to hold the trial in courtroom 3B, and also the defendant's motion in limine. I believe the defense has also filed an additional motion in limine. Mr. Morris, if you can explain as to that as well. Based on where we stand procedurally at this point, when you first gave this waiver, that was prior to there being any deadlines concerning discovery or being able to view the evidence that the state plans to present at trial. Now that there has been an opportunity by you to review this discovery with your counsel, I believe it is prudent to go through these factors again, ultimately to confirm that you still wish for Mr. Rauschbaum to act as counsel. If you please can stand and raise your right hand. Do you swear or affirm the testimony you're going to give will be the truth?
Yes.
You can lower your hand. Mrs. Adelson, you understand that you have, under the Constitution, a right to conflict-free representation. Do you understand this, ma'am? Do you also understand as well that one of your attorneys, Mr. Rauschbaum, previously represented your son in a case or a similar case in this matter?
Yes.
Do you understand that he has a duty to hold in confidence certain aspects of that representation?
I understand that.
Do you understand as well that this could create a potential or actual conflict as it relates to your representation in this trial?
Yes.
As to that conflict, do you realize, or I should say, do you understand that this could affect your defense in some way?
Yes.
Have you had an ability to consult with other counsel as to whether you wish to have a conflict-free counsel?
I'm aware of that, yes.
And as to any potential or actual conflict that may exist with Mr. Rauschbaum's representation, are you waiving this?
Yes.
Thank you. You may be seated. And again, so it's clear why I'm doing this, ma'am, at this stage, as we move closer to trial, things are going to occur rapidly, including rulings on the motions that you filed, rulings on the state's motion, how this is going to affect the evidence, and how this will ultimately affect your trial. At any point, if you decide that you are no longer willing to waive this conflict concerning the representation, that is something that I'm going to need to address. Do you understand this?
I do.
If defense counsel as well becomes aware before the next hearing that the conflict is no longer waived, please bring this to the court's attention.
Yes, Your Honor.
All right. Let's go ahead and start with the motion that procedurally bears on whether the case will move forward or not. The defendant's motion to dismiss the indictment for pre-indictment delay. Mr. Morris, Mr. Rauschbaum, whoever is arguing this on behalf of the state, I'll allow you to proceed at this time.
Judge, may I approach the lectern?
You may.
I got it right, lectern.
A+ for use of grammar. Go ahead, sir.
So, Judge, you've read the paper, so I'm not going to go into too much detail other than what's said. I don't want to repeat myself too much, but just to point out a couple things. Here there are two components that need to be shown. You need to show prejudice. Well, you need to show a delay, first of all. That's clear. I think that's clear on the facts. Murder was in 2014. Donna Adelson was a suspect in 2016. An affidavit was released in 2016 showing she was a suspect. You'll see the evidence in this case. We've had an opportunity to review the exhibits the state intends to present is the exact same, pretty much, evidence that existed in 2016, that existed in 2019 in the trial of the first trial, Catherine Magbanua and the others. So you do have a time delay. What we have to show is prejudice.
So before you continue as to that, and really all the details as to this matter, specifically, when are you alleging the first time is Ms. Adelson could have been charged?
She could have been charged in any time. She could have been charged in 2016, right? She could have been charged. They had affidavits for arrests of certain individuals that they didn't do in 2016. So she could have been charged in the first indictment of Catherine Magbanawa, Sigfredo Garcia, and Luis Rivera. She could have been charged at any point in time from there on forward.
The reason I ask the question is because the motion makes reference to 9 years, but ultimately, when someone can be charged is when the clock starts ticking, at least by the logic of your motion, correct?
I mean, yeah, look, she could have been charged any time after 2014, right? I don't know.
I wouldn't go that far.
I'm just saying, look, this is not, and to be clear, this is not a statute of limitation. There is no statute of limitation.
There is none.
So we agree with that. But she could have been charged any time after the murder. But what's clear is that the evidence that they're using today, they had in 2016, right? Much of the trial in 2019, 2022, and 2023 is the exact trial that we're going to hear in 2024. So the only new evidence since then is her trying to get on an airplane to go to Vietnam, which we don't think is evidence, right? So essentially, their trial is based on wires that existed in 2016, emails that they had in 2016, text messages that they had in 2016, right? And they certainly had it in 2019. So 9 years is 9 years from, I guess, the murder, right? But if you're looking at it in any component, you're looking at what would fit under Florida law, under the 11th Circuit law, certainly a time delay, okay? So when you get that, then you have to look at the prejudice component, and you have to look first at the prejudice component. And you see here that because of that time delay, there are records that no longer exist that would show that she needs to defend herself against two of their main components of their case. So two of their main components of their case are going to be, and they're both brought in by Sergeant Corbett. Two of their main components of their case are call patterns, and I use the word patterns lightly, because in order to show a